Well, good morning or afternoon, everyone, and welcome to our presentation and virtual roundtable discussion today on employee recruitment and retention strategies, legal risk mitigation tactics. My name is Nicolette Belliveau. I am a labor and employment lawyer in our Moncton office, and my co-presenter today is Brad Proctor, who's a partner in our Halifax office with a practice focused in labor and employment. So the problem. Right now, we kind of have a perfect storm going on when it comes to the labor market here in Atlantic Canada and really more widely in Canada. We have an aging population, which is causing, obvious difficulties in recruitment. We have the immigration. So with the pandemic has caused a slowing down of immigration in the past year, which has made it difficult to fill some of those gaps in the labor market. We're also experiencing a skills shortage. So what we're seeing is that the pace of the skills demand from employers and the skills that they need are changing more rapidly than the training and skills production system. So for example, our education systems and universities and colleges can keep up with. And finally, we've all read about it. We've all heard about it, the term the Great Resignation. So, in a February 2022 poll that was conducted here in Canada by Ipsos, it showed that 36% of blue collar workers and 21% of white collar workers in Canada had changed jobs in the last 12 months. So put all of those kind of factors together and we have a perfect storm right now in our labor market. So, what's the solution here? We need both retention strategies and recruitment strategies. So for retention, we want to be able to keep what we have, and on the recruitment side, we need to get more of what you need. And these two things obviously are interrelated. So what, as an organization, is implemented to keep existing employees should aid in recruitment strategies and vice versa. So we're going to just look at the legal perspective on these recruitment and retention strategies here today. So any recruitment or retention strategy has legal implications, and we need to consider what are the risk mitigation tactics that we can take to reduce or quell those potential legal implications of all those different strategies. So just briefly, we want to touch on a few maybe less effective strategies when it comes to recruitment and retention. What kind of won't work? Fixed term contracts. You can't require to work out a contract. It's only really a monetary impact. Requiring unreasonably long resignation notice periods and non-compete clauses. And on the non-compete clauses, we've seen in Ontario, absent some key exceptions, these have become essentially illegal. So in Ontario, so we could definitely see this as a trend expanding across Canada and eventually in our region in Atlantic Canada. Non-competes also are typically viewed in a negative light by employees, and they're also very difficult to enforce because they have a high legal threshold. We do want to note, though, that non-disclosure and non-solicitation clauses to protect intellectual property and clients obviously are still relevant and pertinent to have, but the non-competes itself are becoming more and more challenging. Go ahead, Brad.
I'm going to add something to that, Nicolette. Those are very
Yeah.
good points. It's funny, the perspective. We've been doing these seminars for many, many years, and we've done seminars, in the recent past about, you must have good fixed-term contracts or good termination provisions, or restrictive covenants, and it's interesting to see how kind of the bargaining power in the employment relationship changes. 6, 7 years ago, employers held more of the bargaining power. We had the jobs. If you wanted the jobs, well, you were going to sign the contract that we put in front of you. And what we're seeing is kind of the bargaining power of the workforce, being more choosy. And I know in practice, the employment contracts that we used, 7, 8 years ago, which many of you have drafted and have implemented, you're probably seeing as well some employees that are pushing back on clauses. Nicolette's already pointed out the non-competition clause. Those were always unpopular. Employees signing on and thinking, geez, I'm going to be hung up for a year after I leave and can't compete. So now we've seen Ontario take action and actually legislate those out for most classes of employees. As Nicolette mentioned, non-solicits and non-disclosures get you what you need, in my view, by way of protection. But other clauses like probationary periods, we're seeing a lot of employees push back on long probationary periods. They're saying, well, if I'm going to leave my employer and come work for you, and you're going to hold a probationary period over my head for 6 months or 12 months, maybe I don't want that. So we're seeing those types of things get pushed back on in many cases, and the client's calling and saying, do we really need these probationary periods? And if you have a good termination provision, well, maybe you don't, is the answer. The other thing we're seeing is termination provisions, those termination provisions that say you can be let go by providing you the minimum employment standards or labor standards code notice and no more. We're seeing some pushback on those. So the contracts that you had in place, they're legal and they're legally enforceable, but when we look at the market, they may not be market based on the current job market.
Yeah, those are really, really good points. And we're going to get into kind of the nitty gritty of all of those different points that Brad mentioned when we get into recruitment and retention. But it's like it says, the market has changed so much. So we kind of need to make sure that we're adapting to the market as it is currently. So just briefly on benefits and policies, just, generally, benefits and policies do play a significant role in employee retention, and it's important to understand them from a legal perspective. So when we're talking about benefits for existing non-unionized employees, we can't typically change the employment agreement to reduce benefits unilaterally. We can't change it unilaterally to reduce benefits, but benefits can be unilaterally increased. With respect to unionized employees, new benefits obviously must be negotiated through that process. And with policies, with unionized employees, we need to make sure it meets the legal test. We call it the KVP test, test for any new policy that's put into place in the workplace. And with respect to non-unionized workplace, we want to make sure that the workplace policies are enforceable, and that they meet those requirements, and that there is a good written employment contract in place before hiring that sets out benefits and such. So we're going to start with some key retention strategies. So you have to give your employees a reason to stay, the ones that you have now. So recent numbers have shown that some of the great resignation, that tendency, those numbers are starting to slow down. However, there's still a huge number of migration in the job market, which can have huge impacts on pretty well any organization. So on the topic of retention, one big piece of retention is people and culture. So, Brad and I, we're lawyers. We're not necessarily HR experts, but we do have our sister advisory group, consulting group, MC Advisory, and they do offer people and culture services. They offer, strategy and transformation to help you with employee engagement. They can design and develop compensation, benefits, training and development, and also different program development. And they also deliver solutions such as their very popular HR as a service offering. So we also have, on the market, these type of services that are available to help on the people and culture side when it comes to retention. So firstly, flexible work arrangements. And the strategy here is to be flexible. So during the pandemic, a lot of organizations realized, and we realized, I realized that I could work from home, I could work flexibly more than I really thought that I could. And I know a lot of employees also realized that. And now that they've had that experience of having that flexible work arrangement and being able to work from home, they want to keep that benefit right now. So, in that same survey I mentioned earlier, one of the top 5 reasons Canadian workers were leaving their jobs was flexible work schedules. And they said that, well, on the white collar workers, 37%, and for blue collar workers, it was 33%. They stated that they would consider new job opportunities with more flexible scheduling. So it's obviously something that's really top of mind for employees. And there are so many different forms of flexible work arrangements that we can put into place, right? So think part-time. We can do variable hours, variable days, compressed work weeks, job sharing, the full remote or work from home, and the hybrid. So sometimes in the office, sometimes working from home. So there's a lot of different variations when we talk about flexible work arrangements. So we can see here that there are, a whole bunch of potential legal implications when we're talking about remote work or work from home. So employment laws still apply to any employee who's working from home. And when we look at this, there's some obvious risks and maybe some less obvious risks. So obvious risks, when you have employees working from home, the one that typically jumps to mind is data privacy and security. So how are we going to ensure all of that while they're not on site, and how are we going to ensure that documents and private information are going to be protected? But there's also some less obvious things. So say there are employees working in another province than where you are located. The laws of that other province could and are likely to apply to that employee that's physically working in another province. So it can get a little complicated. For example, also, is a work from home employee eligible for workers' comp if they injure themselves during their employment when we work from home? And there was a case in Quebec that made national news. An employee was working from home. It's Air Canada. She worked in Quebec. She was working from home, and she fell down her stairs on her lunch break, and she applied for workers' compensation because she injured herself on the fall. And the commission determined that the injury did take place in the course of her employment, and she was eligible for workers' compensation benefits. And there's also all the whole question of civil liability. So say another person injures themselves in an employee's home office, there might be an argument to be made that the employer is vicariously liable for that injury. So how do we mitigate, those risks? What are some solutions that we can put into place here? So the first thing is to kind of consider and implement alternate ways to fulfill, the legal obligation for those remote workers. So it's always important to remember, if the employee is physically working in another province or even another country, the employment related laws of that place could and likely will apply and have to fulfill them. So we have to make sure that we understand, what under those laws, what are the rights and obligations, because they obviously can vary and do vary from jurisdiction to jurisdiction. It's also super important to have clear and appropriate policies when it comes to working from home, remote work, or flex work. And what are the clear expectations on work hours, performance, attendance, privacy and confidentiality? What are the requirements for the workspace? And it's also important to have a reservation of right to change if it doesn't work out. So if the employee is working from home and it's not working out, that as an employer, you reserve the right to change what the setup is at that time. There's also, of course, the employment agreement, the reservation of employers' rights to end the work from home, remote work, flex work situation. What are the safety requirements? What are the workplace setup requirements, data, privacy? There's also, insurance. We might want to consider extending business liability insurance to workers' premises, or require employees to maintain a certain level of insurance. So if anyone wants some more information on flexible work and hybrid work, we do have articles, and we've given a webinar back in November on this same topic, and the recording's up on our website. So those resources are all available there. And I'm going to pass it over to Brad for the next retention pieces.
Great. Thank you, Nicolette. So I'm going to talk about a trend. It's a trend which is coming our way. It's if you are an employer in Ontario, it's already come your way, but it's likely coming our way in Atlantic Canadian provinces. But we want to talk about it from the perspective of sometimes we have to do things because we're mandated by legislation to do them, but sometimes we can use them to our strategic advantage as well. So I want to look at this issue from both of those perspectives. It's interesting. I can recall when I started work, when you left on the weekend, your computer, which was a large screen and a box with cables drilled to your desk, stayed in your office, and your voicemail was a blinking light on your phone that you might check when you came in on Monday, and that has all changed. And we're all connected 24/7. And when that first started with the very first, for me, it was the first iteration of the blue gray screen BlackBerry with the little wheel on the side. Everyone said, oh, you're going to have freedom and you're going to be able to work remotely from the office, and you're going to have more time. And well, that did not happen. And I think everyone probably shares that sentiment somewhat. So that's what this is about. That is the problem, is we are all connected 24/7 through our phones. And this right to disconnect is something that in Ontario has become legislation. So we already mentioned a moment ago the issue of Ontario has outlawed non-competes. The same legislation, the same act that outlawed non-competes also introduced this requirement to adopt a policy on the right to disconnect. So in the province of Ontario, as an employer, if you have 25 or more employees, you must adopt a policy on the right to disconnect. And there's a bit of a lead time. You have until June 2nd, not much, if you're from Ontario, June 2nd of 2022 to get your policy together. And that policy must speak to the issues in your workplace with respect to the right to disconnect. What they're speaking about specifically is defined in the legislation, and it is a right not to engage in work-related communications, including emails, telephone calls, video calls, or sending or reviewing other messages. So that is what they're talking about. So it really is getting at the core of the kind of BlackBerry, iPhone, Samsung culture. Now, the legislation is pretty vague. There's not much in it as to specifics. We know that you have to have a policy. We know it applies to workplaces that have over 25 people. We know that it doesn't apply to certain crown corporations. And we know you have to adopt a policy. And the policy doesn't have to be a standalone right to disconnect policy. It can be embedded within your hours of work policy. If you have a policy on hours of work, you can embed these requirements in that policy. And what I would say is it does not say that there's an absolute ban on emergencies, that you can't answer emails, but it says you have to have a policy. And because that's happened in Ontario, Ontario being a larger province, Ontario, Quebec, BC, they often are at the forefront of advancements in employment law. So we can, speculate that probably in the coming years, we may see something similar adopted in the Atlantic Canadian provinces. And so you may want to get ahead of it, but you might want to get ahead of it because that is one of the things when employees are queried about dissatisfaction in the workplace, the requirement or the expectation that they be connected 24/7. So if Brad Proctor on Friday afternoon today decides he wants to get a real jump on Monday, he sends out 25 emails to people for things to start on Monday, that's going to stress them out. And so the question is, do I really get ahead by sending that out on Friday, or am I able to send those out on Monday? So things like that. So you might want to consider adopting a policy. And the requirement is to adopt a policy. The requirement is not an absolute ban on communications. And so it may well be that my policy says any emails that are not essential and do not need to be required within the business day, need not be communicated that evening and can be communicated the next day or over the weekend. However, urgent matters that require attention, communication. So it needs to be a policy, not an absolute prohibition. We'll go to the next slide. Another tactic on, we talked about recruitment, but on retention is paying more to stay. And we say pay, but you can really get creative here on, it's really talking about incentive programs, retention programs. And I know a lot of employers have those in place. But getting creative is something that I encourage you to share a little experience from McInnes Cooper. A number of years ago, we were experiencing some issues with the retention of lawyers. And so we found that when young law students, myself included, come out of law school, they have large student loan burdens. So we developed a student loan program whereby McInnes Cooper effectively takes over your student loan. You still make payments, but the longer you stay, the more McInnes Cooper will pay off towards the payment of that student loan. And so it's a retention type program. So that's what we're talking about. What is it in your workplace that makes it people tick? What incentivizes them? What type of program can you put in place? I know the things that I commonly see would be things like long-term incentive plans, or LTIPs as we commonly hear of them, bonus plans, different types of benefits. I know I had a case where a particular company, a construction company, was looking for a project type worker, and in this current economy, you go there for 3 months and then someone else is going to give you double that salary someplace else. So part of this person's compensation was built into an incentive whereby there was a kind of a trust account set up, and each quarter that the employee stayed, an allotment of money was paid into that trust account. And it was visible. The employee got to see how much was building up in that account. There was interest on it. And so they could see that that account was being built up. But there was a vesting provision that required that the person stay until the end of the project, 2 or 3 years, whatever it was. And if the person left before that, then that whole account went poof. And so it was a visible tool to show that employee that look at all this value that you're building up, but you got to stay here to this certain date to get it. A simple solution to a problem in this case where we needed the project manager to stay on. So one of the things about those provisions are, as employers and as advisors to employers, we can tell you, wherever you draft a contract or a letter or a document that has any ambiguity or any vagueness, it will always be construed in favor of the employee or always be interpreted in their favor. So it's got to be absolutely clear. So it's got to be clear what happens if the employee leaves, if they resign, if they're terminated for a cause, without cause, if there's a constructive dismissal. And sometimes there may be different things. It may well be that if the person is terminated for cause, you've made that decision, so there's a different consequence than if they resign to join a competitor. Or it may well be that if they retire, then that's different than if they resign to join a competitor. So different things happen. And what we'll see is that a lot of policies, LTIP policies over the years have used this concept of active employment. And I think a lot of employers took comfort that as long as we said, you must be actively employed on the date of payment in order to receive the payment or whatever it is, that they were fine. And there's been some cases in the last couple of years that have eroded or stripped away that notion of the word active employment. And the most famous one comes from our own backyard. I'll talk about that in a moment. But simply having that active employment language is often not enough. And so, as we mentioned on the slide, what are the best practice mitigation tips we give you? Well, tie it to retention. Retention is a valid purpose, and sometimes people don't spell out why they're doing things. Like they just rely on the lawyer clause. But I think if you say this is a retention tool and this is a benefit for you as long as you're retained, that helps inform the lawyer clause that if you quit or go, well, you don't get it because you're contrary to the purpose of the retention tool. As I mentioned, get rid of any ambiguity, and also be clear that if we terminate you without cause and you're entitled to a notice period, then you're not to be paid or accrue any additional benefit under this plan during that notice period. The next slide, please. The case that I was going to refer you to, which I said arose from our own backyard and went all the way to the Supreme Court of Canada, is the case of David Matthews versus Ocean Nutrition. And Ocean Nutrition was a company that had kind of developed the Cadbury Caramel secret, except with fish oil. And it was an omega-3 provider. And of course, they had some intellectual property. And they had an LTIP, a long-term incentive plan, which was tied to a future sale of the company. And so basically, if this company was sold, and you were present, you were actively employed, then you would be paid out under that LTIP. And so Mr. Matthews, he was kind of, in a way, the part of the brains of the operation. He was a scientist that was behind a lot of the development of the technology and the omega-3 acids and all of those things. He left the company to go to a competitor in a different country. And so lo and behold, about 15 months or so after Mr. Matthews left, the company was sold for millions and millions of dollars, and that was all very public. And of course, Mr. Matthews then turned his mind to, oh, geez, what about my LTIP? Had I been employed during that period, I would have received, no, he would have received millions, of over $1 million. And so what then started was an action for constructive dismissal. And it was basically him saying, well, I wasn't fired for cause. I left because I had to, because you bullied me or you treated me unfairly in the workplace, and it was a constructive dismissal. And so it went all the way through the court system, and the judge in Nova Scotia said that he was constructively dismissed. They said that the reasonable period of notice for him was 15 months, and that 15 months, if the actual LTIP, the event that crystallized the entitlement under the LTIP, occurred within that 15 months. And so the way the language was drafted, it said you must be actively employed at the date of the event. And so the employer said, well, no, he wasn't actively employed. He had quit, and he got an award for damages, a constructive dismissal, but he wasn't actively employed. And long story short, it went all the way to the Supreme Court of Canada. And in many, many pages of legal decision writing, the Supreme Court of Canada said, well, it's not his fault that he wasn't actively employed. It's actually your fault, employer. And the purpose of common law notice is to give someone a cushion so that they can find a new job. And you could have been much, much clearer in your language, employer, that this did not apply during a period of reasonable notice. So he was found to be entitled to the LTIP incentive under that plan. So I'm going to pause there, Nicolette, unless you have any comments you want to make about any of these points. And
No, I think you covered it.
I
Great.
believe you will be picking it back up to
I
tell us
will.
about some recruitment strategies.
I will. I'm going to kick it off with a few recruitment strategies. Thanks, Brad. So, on recruitment, before we jump into the strategies, we just want to just do a high level reminder on inducement. So next slide, please. Perfect. So, you know, we can all imagine the scenario. We're all looking, every organization is trying to recruit right now. So a really enthusiastic employer basically says anything to persuade a candidate to come on board, and that's their strategy. Well, there's a legal risk of that, which is inducement. So that is inducing someone to leave their current job to come and join your organization. And that inducement factor can increase a notice period if the employment is terminated. So the risk there is, should the employment be terminated, there'll be a larger amount of notice that requires to be paid. So it's going to become more costly at the end. So how do we mitigate that? We're going back to, the employment agreement, the employment contract. So the contractual termination clause, making sure that that is well drafted, that is tightly worded, and having a contractual entire agreement clause. So, casting our net wider when we talk about recruitment. That's the first strategy that we're going to discuss. So the first strategy, obviously, when we're looking at casting our net wider, next slide, please, is immigration. So last month, our monthly webinar was on immigration and tactics to expedite the entry of foreign workers. And the recording is available on our website under our insights. So immigration is quite obviously a net that we can recruit from, that employers can recruit from to expand their workforce. The next pool would be, the unconsciously excluded pool. So the strategy here is to kind of look at, the current makeup of the organization, of your employees, and maybe seek out those maybe non-traditional potential employees who maybe unconsciously has been excluded from the recruitment efforts in the past. We can think of visible minorities, women, people living with disabilities, and the list goes on. So the legal risk that comes into play there is, obviously human rights. So all human rights legislation across Canada prohibits against discrimination against any of those groups I just mentioned. And there's also the duty to accommodate that comes in under human rights by employers to accommodate those people, depending on what it is, up to the point of undue hardship, right? So how do we mitigate that risk? Well, we can have diversity, equity, and inclusion policies, having diversity, equity, and inclusion efforts in the workplace, and also having an understanding of accommodation, of what policies are in place, having training at all levels. And on that point, we do have our MC Legal Labs. We have a session specifically on the duty to accommodate by employers. So it's important to understand all those points if we're going to go and seek out candidates from those what we mentioned are unconsciously excluded pools. The next net that we can look at is hiring for attitude and training for skills. So this we've seen, I think, more and more lately is, I mentioned earlier, there's a skills gap. So instead of looking for the skills, we're going to hire someone who's less qualified, but may have a great attitude, and they'll have to be trained up for the skills required for the position, because you need to fill the position. But the risk there and the implication there is, what if it doesn't work out? What if their performance never meets what you need in that role for your organization? So how do we mitigate that? There's the contractual probationary clause. Brad did mention that we are getting some pushback on maybe the length of it, but in this case, make sure there is at least, if you can get it, a probationary clause that if it's really not working out, they can be let go under that. Contractual termination clause. So again, making sure that termination clause is well drafted, and if it's not working out, that's an option. And having a good performance management training and a performance management plan in place so they can learn and train up for those skills. And if it's not, we can manage that their performance can be managed within the workplace. And the last one here is hire from a ways. So, cast the net wider across Canada or across the world. And then there's the question is, are they going to relocate to you? So the risk there is the relocation costs. What are the costs? What are the entitlements if it doesn't work out and they, say it's an employer in New Brunswick, here in New Brunswick, and they have an employee come in all the way from BC. They uproot their life, their family, and they come here. It doesn't work out. Well, then what happens? So again, how do we mitigate? There's contractual terms in the agreement clarifying what are the relocation entitlements, under what criteria, and these, again, it can be tied to retention. These are ideally tied to retention. So those relocation entitlements are tied to how long they stay with the organization. And again, when we're looking at hiring from elsewhere in Canada or the world, there's also the question that we have to say, do they need to be here? Do they need to physically be on site? So maybe we can look at, again, flexible work, remote work, but then again, that opens up the other legal risks of, the other jurisdictions, legislation, other jurisdictions, all of those things. But that is also an option for hire from ways, having full remote employees that aren't on location to where you are. And I'll pass it over to Brad for the next piece.
Great, thanks, Nicolette. This next piece is part of Nicolette's three strategies. She's talked about the recruitment piece. So this is the second one, and it's a little bit similar to something I've already spoken about, which is kind of the retention programs, but it's basically pay to come, or to use a more simple term, signing bonuses and things of that like. Those are good tools. One of the things that we have found, there's a report done. It's a report by Randstad Canada. It's a talent management survey. It's fairly fresh. It's February 7, 2022. and it compiles a list of the top reasons why Canadian employees are leaving their jobs. And the number one reason is compensation, which I don't think is all that surprising. But if you read further in the study, it says when we're talking about industrial construction, or what I'll call blue collar workers, that factor of competitive compensation is 65% of the reason people are moving their jobs is because of that. It's a little less with professional or white collar workers. It's 60%. And it gets even higher for workers age 18 to 34, it's 70%. So, we've seen that trend for a while where, young workers in an industrialized workplace, they're not motivated by the gold seal pension plan. They're looking for what they get in their pocket or on their paycheck on day one. So that's an interesting trend. The second top reason why people are leaving their employment are better improved benefits in different workplaces. So similarly, for blue collar workers, that's a 38% motivating factor, whereas for professional white collar workers, it's 35%. And so when it comes to providing a carrot, if we go back to the first slide, there was a carrot there. We're talking about the signing bonus, the carrot, and there's probably a stick, which is hidden out of view somewhere. But the carrot is there. And if we go to the next slide, what we're talking about is making sure that whatever you provide by way of a carrot or signing bonus, similar to what I advised on retention programs, make sure that your language is clear. And there is going to be some risk. So, people say, well, what if I provide the signing bonus and they leave very promptly after receiving it? Well, there's risk. But in this market, you have to take some risk in order to get good employees. And there are ways to mitigate that risk, once again, with a good contract. I have seen clauses that would say, you'll get a signing bonus, and a certain percentage of it is paid immediately, and a certain percentage of it is paid after a certain period of time, 6 months in, or something to that effect. You can, of course, have clauses that say if you leave, you have to repay the signing bonus. That's not necessarily getting the spirit that you want. You're almost, signaling to the employee on day one, you might leave, you might not like it here, and we want the money back. But you can do that. Good luck getting it back. It's tough to go after suing employees and getting money back. And you can do some of the things like I've talked about before. Put a vesting period on it where you get so much of it on a pro rata basis over time, but you can't take it or have it until it vests. And it doesn't have to be cash either. It can be things like a vehicle. You'll get use of a vehicle while employed, and maybe it's a nicer vehicle than's otherwise required for the job, but that's a perk. And the vehicle comes back when you're done. Perhaps it's accommodation. We'll allow you some accommodation. Or perhaps it's enhanced training or enhanced technology. It can be any of those things. And I have seen some clients that will provide different levels of technology. And this dovetails in with what you were saying, Nicolette, about kind of work from home, where we're hiring people that may not ever work in our province, or they might not work in our city, or they may work from home in the same city. You can provide this is the basic technology that will provide you, and there's a spending account for you to buy some enhanced technology for your home, and maybe you get to keep it, or if you leave before a certain time, you don't have to give it back. Those types of things can be incentives. Moving on to the next strategy is we'll call it tapping into the gig economy. And the gig economy is something that, once again, has been a bit of a trend. And I know as a traditional employers, going back 20 years, 15 years, we're comfortable with, employees that, are full-time or part-time, but there's this ongoing relationship. And they're knitted into the fabric of the organization. They buy into the culture. We know where they sit. We know where they work. We control their hours of work. We control everything, right? That's kind of what we've been comfortable with historically. That started to change. I know there was a case in Nova Scotia probably about 10 years ago now called the Egg Films case, and you probably remember that concept of Egg Films, which was a film production company, and they had some gig. They were gig. Their whole workforce was gig workers, and they had some gig workers that were tangentially linked to the company. Some of them might work for a day in a month, or some of them might never work again, but they unionized the company. And the whole notion was, well, can we have these gig workers unionize a company? And ultimately, in Egg Films, it was found that they could. People have a right to unionize. So there are strategies we're not going to get into here about kind of labor relations and union issues. But point is that that trend has been growing. And looking at a few studies, in 2016, approximately 10% of the Canadian workforce was what we'll call gig workers. And gig workers, I call them gig workers. You might hear them as, independent contractors, self-employed, brokers, freelancers, individuals that fall under those terms was about 10% in 2016. Come forward 3 years in 2019, and we see that that percentage is up to 17%. Now, I don't have a current statistic for 2022. 2019 is the most recent statistic, but I bet you that that statistic is getting upwards of above 25% or more. So that's becoming a quarter of the Canadian workforce, or maybe even more than that. And I see the need, even in our business, the ability to attract, recruit, retain lawyers. Some of our traditional notions that we need to have a lawyer like sitting down the hall so we can go give them the file. Like, we've questioned all of that. We said, do we really need that? And why can't the lawyer sit in Alberta and do work for us in Nova Scotia? They can. Or why do they have to be a full-time employee? Why can't they? We've got a particular case or a particular project, and we're going to engage them to work 45 hours this month on that project. Why can't they do that? They can, right? So the traditional notions that we've had, we need to come to grips with, and we're not doing it. It used to be it used to be thought of, oh, we're going to hire part-time casual employees because then we don't have to do statutory deductions, we don't have to pay them benefits, we don't have to pay them reasonable notice, all those things. That's really not what's driving it this time. This time it's just finding bodies and people to do the work. Flip to the next slide, please. So, the legal pitfalls here, of course, are to make sure, once again, that everything has got to be clearly documented in writing. And this is one of those areas that having the clearly documented contract is good. It's a good step, but it's not all of the way there. It kind of, I don't know who said it, but I'll say it. If it walks like a duck and quacks like a duck. So you can say you are an independent contractor. You are a broker. This contract says you are such. You can say that. But if you don't actually behave that way, if you then set the person's hours of work and you tell them how to jump and how high and you pay them by the hour and they got to use every technology, then they're not the duck that we've said. They're employees. So having the contract is a very, very essential, important step. But behaving that way is equally important. And so, because if you don't behave that way, then all of these people have the same rights as employees. And the risks to you as an employer, and I have had this happen, where an employer had a creative idea of having this workforce which was all contractors, the CRA did come by and someone applied for EI or something like that and triggered the CRA. So the CRA came in and audited and said, like, all these people that you've not been putting remittances back on for tax, CPP, EI, we deem them to be employees and go back retroactively and submit taxes, EI and CPP. So that's a risk. Or the other risk is that the person works for you for multiple years and you go to dismiss them and you don't think they're owed any notice, but they're a 20-year employee. I've seen that happen as well. In fact, I had a Nova Scotia client, maybe on the line, they may recognize this, that had someone like that working in Ontario for years and years and years. Contractor, called them a contractor. Employer said, we don't need you anymore, thanks, and we get a lawsuit looking for exorbitant amounts of reasonable notice. So those are things you've got to keep in mind. And so keep in mind the contract's important, how you behave is important, the deduction issue, the coverage with workers' compensation, all of those issues are important. And we're starting to see in the case law litigation develop over this issue. And there's been a lot of cases, public cases, in the last number of years on this issue. Probably one of the most famous ones is the Uber case. Uber, of course, being that kind of ride sharing program that only hired independent contractors or freelancers. They did not hire employees, and there was a class action lawsuit which has been permitted to go forward, finding that they are akin to employees and there should be the employment benefits and things of that nature afforded to them. And there's been a whole slew of those cases. There's been one against Skip the Dishes, so a similar type of entity. There's been one against Deloitte & Touche. Deloitte & Touche, the large professional services firm, had an arm of their business called their document review section, where they hired contractors. And similarly, they were claiming rights to overtime and those types of benefits. So there are pitfalls with those. So to make sure that you have it documented and you behave appropriately, what I mean appropriately is in accordance with what you've documented. So really, in a nutshell, I think what Nicolette and I have tried to do here today is we've tried to come with some creative solutions. We're not here saying, I don't want you to go away from this saying, oh, we must adopt a work from home policy. No, but I think it's to your benefit to start thinking that way. Or I must adopt a right to disconnect policy. No, you don't have to, at least in Nova Scotia or Atlantic Canada, but you might want to. It might give you better morale with your workers. Right? We're not saying you have to go hire gig workers, but why not try it? Why not dip your toe in the proverbial water and hire someone on a contract for a specific project basis and see if it works and it fills that gap? So that's what we want you to take away from this today. The problems that you're having with recruitment and retention, there are some solutions, and they just require kind of a different shift, a different mindset. So I'm going to stop talking. Nicolette, we have another slide kind of on our training, and you've talked about it a little bit already, but maybe I'll let
Yeah.
you talk about MC Legal Labs.
Yeah, so I did mention MC Legal Labs when it came to the duty to accommodate. So we do have MC Legal Labs here at McInnes Cooper, and I have my notes on this. Just give me a moment.
And while you're looking for those, Nicolette, what I know of MC Legal Labs, of course,
Yeah.
is over the years, we have developed a host of knowledge on training on virtually every aspect of kind of what I'll say law and human resources that touches the workplace, from things like we're talking about today to how do I implement a safety culture, or how do I implement a drug and alcohol policing regime, or how do I do a harassment prevention policy, all of those things. And so apart from drafting and helping you prepare those things, we've also developed hour, part day, full day, customized seminars, which
Yeah.
we can deliver in your workplace. So that's kind of, in a nutshell, what we're getting at.
Yeah, that's exactly it. So, at this time, if anyone has any questions, we would really encourage you to put them in the question box, because we do have a little bit of time to get to any questions. So it's exactly what, like Brett said. So what MC Legal Labs are, they're customizable training workshops that are led by our labor and employment team here at McInnes Cooper, to kind of support that continuous learning of your people leaders, helping them provide some practical skills to mitigate and manage legal risks to the organization on certain topics, like essentially what we talked about today. And what's really great about these MC Legal Labs too is, as Brad said, we have over the years have developed quite a bit of them. We have a catalog of existing workshops that can be reviewed, and they're also offered virtually. So, if that's of interest, please reach out to either of us or any of the McInnes Cooper team on the, and we can definitely set that up for you. So there's a large variety of topics that we can provide either in person or virtually.
Perfect. Thank you so much, Nicolette and Brad. We've got some questions coming in now from our attendees. So we'll start with this one I'm seeing here about employment agreements. Do you suggest having a specific clause in employment agreements if the work arrangement for an employer is hybrid?
So I'll take an initial stab at that. I'm assuming we're referring to the hybrid work from home, work in the office. I mean, I do recommend that. And I recommend that it either be a specific clause in the agreement or a clause that references to a policy or program on that. It may well be that you want some control over that hybrid. You may want to be able to set the number of days a week when the person's at home. You may want to change that. You may want to revoke it entirely. You may want to have a period where it's a project where you want the person entirely in the office. And so you want to retain the flexibility on those types of things. I know, so yes, it's got to be in writing somewhere, whether it's a clause in the employment contract or whether it's a clause in the employment contract that references to a policy. You want the ability to be able to control those things. Otherwise, if you give it, the way it works in employment law, as a no good deed goes unpunished, as you've probably heard me and many others say, if you give something to an employee and then you try and take it back and you haven't reserved that right to take it back in writing, well, then you can be into constructive dismissal territory. So that would be my answer. And Nicolette, I welcome anything that you may have on that.
Yeah, I would agree completely. I mean, you want to have the right, you want to retain that right to recall or to change the arrangement if it's not working out, because it just might not. And by having some specific wording in there, like Brad said, either having it in, where the place of work is, or make reference to specific policy or policies, is a way that as an employer, you can protect yourself in reserving those rights. And if it's not working out, or you want to change the arrangement or need to change the arrangement for any reason, you can still do so.
Perfect. Thank you both for that. So our next question is around accommodations and discrimination. So the point between pregnancy accommodations and discrimination for safety, should you make employees disclose a pregnancy?
So I guess I can take an initial stab at that as well. So there are certain requirements depending upon your province as to pregnancy and when you must disclose and give notice. Obviously, being humans, we can visibly see certain indicia of pregnancy, and so it's one of those things that is there a policy? Well, yeah, you should have a health and safety policy. Do you need a specific policy on thou must disclose your pregnancy? No, but I think you should have employees have a legal obligation. Every statute in Canada, from a health and safety perspective, has a section that says that an employee has to take all reasonable precaution for their own health and safety. And so enunciating that and making it clear to say, like, you have an obligation to be fit for duty and safe for duty at all times, regardless of what condition you may come to work in, whether it's some type of a psychosomatic condition that causes you to lose alertness, or whether it may be pregnancy, or whether it may be substance. If you're not fit or there are risks, then you have to tell us. You can do that. The next piece of it is, if someone doesn't do that and you have reasonable belief to believe that they may be at risk, as long as your inquiries are balanced, and as long as you're balancing their human right, as long as you're balancing their right to privacy, and balancing your obligation as employer to ensure a safe workplace. All of the time I have clients that are in difficult conversations with employees about a perceived medical condition or a perceived, I will say to you, I don't have a specific example comes to mind of a pregnancy, but I all the time have clients that say, because keep in mind, in human rights law, as an employer, once again, no good deed goes unpunished, but the law is kind of stacked against you. And so if an employee asks for something or tells you something like, I need an accommodation, you have to act. But there's also that subset of law in human rights where you reasonably ought to have known. So as an employer, where you reasonably ought to have known that someone needed an accommodation, you have to act. And that's those cases where the person's, absenteeism and they're reeking of alcohol, and you just bury your head in the sand and you don't detect the substance abuse problem. Well, you had to accommodate that. So it's okay for you to say, you do a safety sensitive job, or you do a job that has certain risks. Your present condition, whether it be health or pregnancy, causes us a safety risk. Can you, go to your doctor, or can you consult with a company doctor, or can you do whatever to satisfy us that it's safe for you to continue doing what you're doing? As long as you're balanced, you can do that.
Yeah, I would just subscribe to everything Brad said. I think he covered it super well.
Question 3, risks of calling up a potential candidate directly without him applying for a job.
I can take a first stab at that one. I mentioned it. The risk there is, I mentioned it really briefly, is the inducement piece, right? So if you induce someone away from their current position to join your organization, and then it doesn't work out and there's a termination, there could be added onto the notice period at the end. Just calling someone up and saying, hey, we have a position, that's not inducement. There's a fine line there, but that is the potential risk there. If you really induce them out of their current employment to go and work with you. And if Brad, you have anything to add to that?
Well, I agree with you. And your key point that you made, Nicolette, is that the simple act of bringing the opening to their attention is not inducement. And there's a case in Nova Scotia, Bureau versus KPMG, to that effect. So, there's a whole army of companies that make their living, recruitment companies that do that. That, you know, hey, Nicolette Belliveau, I've heard she's great. I want to get her as our in-house counsel, and, you know, hopefully they don't do this, but they call her at the Moncton office and try and recruit her. But that's how that works. It's when they start saying, so Nicolette, how much does McInnes Cooper pay you? Okay, we'll exceed that. Oh, and we see you don't have a corner office there, Nicolette. We'll give you a corner office. And you know, when they start inducing her to leave her secure employment, they've effectively bought Nicolette's service with McInnes Cooper. So that's the risk.
Okay, and what would the extra notice be if a candidate is induced?
So I did an analysis of this issue a number of years ago, and the few things I can tell you are the inducement factor applies most strongly if the termination happens within 2 years of the hiring of the induced person. So if I induce someone away from secure employment and they stay with me for 5 or 6 years, and then we let them go, and they come at me and say, I was induced to leave, the case law would suggest that inducement factor is no longer relevant. So it's really, and it's not a bright line test, but generally speaking, if you let that person go within 2 years of having induced them from secure employment, and keep in mind, it has to be secure employment. If you induce them away from a term job or, you know, part-time work or casual work, then that's not inducing from secure employment. So it applies for about 2 years. And if you do terminate them within the 2 years, the way that courts often do it, and I said you kind of, when I used the example of Nicolette, I said you bought her service. It's almost like they'll say, okay, this employee's been with you for 2 years, and they had been with company ABC for 10 years. You must treat them as a 12-year employee. That's kind of the way a number of the cases deal with it. It's not an exact science, none of it is, but that's the way some of the cases have dealt with it. And the closer you terminate them to having induced them, the more you're going to have that service applied kind of on a month per year basis.
That's great. Thank you so much. Okay, and that looks like that's it for questions today. Thank you so much, Nicolette and Brad.
Well, thank you very much. And thank you to everyone else, Yara, Lindsay, and Crystal, who helped put the materials together and pull this presentation off. So thank you. And thank you to all, I think I saw like 90 some people there at one point. So thank you to all of you for joining in, listening, and asking your questions.
Yeah, thanks everyone. Hope everyone has a great weekend.
Yeah.